Hi, good morning. Today is October 15th, 2025, and it's 6:45 a.m. U.S. Central Time. My name is Reynaldo J. Aguiar Marcano, and I'm recording this video from my home located at the 26714 Valleyside Drive, Katy, Texas, 77494. And again, I would like to highlight the date and time. It is October 15th, 2025, and it's 6:45 a.m. U.S. Central Time. This is important because I'm going to say a couple of things that, if they turn out to be the case, the timing, the timestamp of this video is going to be important, okay? This video is really a continuation of the video that I recorded last night that talked about legal topics. There are three things that I did not mention in that video because, the confidence, there were things that were flagged by the data pipelines that I have running. But I don't have direct proof of these things, so I didn't want to put them in there, right? Because the other things that I said were facts. And as I said in that video, I was concentrating on facts and things that are observations that are demonstrable, right? Those are not interpretations. Those are things that happen and are recorded in different systems that the government maintains and could be audited to see if what I'm saying is the truth or not, right? But these three things are inferences that are derived by the pipeline as things that could be suspicious, but I don't have proof, right? So I didn't want to mix the two things. The reason for that is because, and this is a common thing that they do and they will do, right? If I say something that is slightly incorrect, they will attack the entire set of things that I'm saying that I said one thing that was incorrect, and then therefore, like for example, my former partner, if I say something that is not exactly like I'm thinking it could be, right? If I hypothesis, then she will come back and say, see, you told me the other day that this thing was in this way, and you were wrong. Therefore, Diosdado Cabello is not even aware that you exist. Everything is wrong, right? Like they jump from that little thing to Diosdado Cabello is not the one doing this immediately, right? So I'm very careful not to mix, hypotheses with facts. Because I know that they will attack my credibility, right? That's the only thing that's left for them to do, right? So that's why I didn't mention these things. But there are three observations, three things that were flagged by the pipeline that could be something, okay? And I don't know, and I don't. First of all, I don't think it's my job to know, right? To prove that this is the case or not. And secondly, I don't have the way to do it, right? I don't have the tools or the access to data to see if this is what's happened, right? So the first thing, I'm going to go one by one, okay? So the first thing, and this is the one that I think could be time sensitive. I mean, the timestamp could be important because by the moment I'm saying this, which is again, right now it's 6:48 a.m., I just checked my email and I have not received any notice of the signed order. So I have no way of knowing if what I'm going to say is the case or not. If this turns out to be the case, it proves that the technology that I have, the legal vaccine, is awesome, right? It works. So the pipeline flagged something. It flagged, although I haven't received any notices, right? Among one of the things that I ingested into it was the docket summary of the case in the lower state court. And in that summary, that's how the vaccine found, the index. It's called index 81. So the document number 81, which is the orders that were entered into the record on Friday, October 10th, after, I imagine, right? It doesn't say the time, but I imagine it was after we had the hearing in the morning, in which the judge said, Judge Oscar Telfair III, said that we would be in person tomorrow, the 16th, at court, so I could be heard, right? And this is what's interesting. So I'm going to tell you what the pipeline, I'm going to paraphrase the output, okay, in human language, because this is a pipeline. It's debug output, what I'm saying, but I'm going to paraphrase it. The anomaly that was flagged was that in that docket summary, the number of pages of that notice that was filed or entered into the record in index 81 on October 10 is 3 pages. In contrast, Morgan Heibner's fraudulent drafts have been always between 34 and 37 pages long, right? It varies because she changes the orders. She has the ability to change the orders of the judge depending on the landscape, on her situation, right? So she adapts the orders as she needs, right? So they fit her needs. So because of that, the number of pages changes, but it's always above, say, 30 pages or 32 pages, above that number, right? Yet, the notice on Friday that was entered into the record on Friday says 3 pages. So it cannot possibly be her orders, right? Now, I mean, and this is why this is an inference, because this court is so weaponized that at this point, 5 days almost, right? 5 days after, I still don't have the orders, right? So I have to guess what the orders were because they won't give them to me, right? At this point, I just checked. They haven't, right? I imagine they're going to run this morning to give them to me, but until this point, 6:51 a.m., well, 6:45 is when I checked. They haven't been sent to me, right? Today being Wednesday, October 15th. So the day before I'm supposed to meet this judge tomorrow, right? I still don't have the signed orders. We are supposed in the record since Friday. So now I have to guess, right? That's my only choice in this system, to guess what the orders are. I have to be creative and imagine what could these orders be, given that I know that the notice has 3 pages. I imagine 1 page is the actual notice and the other 2 pages, right? That are the mystery pages that nobody knows. I mean, Morgan Hagner knows what they are, obviously, but besides Morgan Hagner and the judge and the clerk, nobody else knows because the document is marked as private. If you try to download it, the county website says you can't download this document because it has private information, right? So they do this to obscure the record so nobody can download the document, and so I don't get the notice, right? So anyhow, but that's just like the tip of the iceberg, right? Then the pipeline goes into a cascade of implications of this, right? And there's 2 paths that I see of how this in the output, right? On how this could be, right? What could be the situation? One could be that this is a notice saying something about the orders. Imagine something like, I'm just being imaginative, right? Because I don't have the orders, right? They haven't given them to me. So I have to imagine, right? Imagine a notice that says, it could be something like, you are put on notice that you have to meet on the court on October 16th, right? And then the clerk mislabeled the notice as if that was an order, right? It's not really an order. It's a notice to appear on the 16th, right? Imagine that. But the clerk made a clerical mistake, quote unquote, and then it got labeled as orders. And that triggered the appellate court to deny the mandamus petition, right? Which is the outcome that I described that happened already, right? It happened yesterday. So that could be one, right? But in that case, it means that, I mean, because what a coincidence, right? That when, they are in this situation, then this clerk makes this mistake, and that clerk hasn't made a mistake like this when Morgan Hagner files something, right? Before, until this point, this critical juncture point, right? But okay, let's assume for a second that that's one path, right? That's the less damaging path for them. The other path that I see on the debug output is the following. The judge signed my orders. Because I remember, I said yesterday, I also submitted, I wanted to be proactive, right? Because I'm seeing that Morgan Hagner is consistently submitting these fraudulent drafts, adding things to the orders. I drafted the orders based on my notes of what the judge said, and I submitted them, right? So on the hearing on Friday, I mentioned to the judge that the court had 2 orders before the court, right? There were 2 orders. I didn't say that. I said something like, there's only 2 orders today that could be considered, and there's only one that reflects the verbal rulings as they were, and it's my order, right? That's all I said. The judge, stopped me, right, from talking. So I couldn't say anything more than that. I didn't really show the orders that I had submitted. I did not present them. I did not lay predicate. Right? I did not, and they have more than 10 motions that the court hasn't ruled on. And how is that they saw these orders? right, to then sign them. So I'm going to tell you what is the implications of the pipeline sees, right? First is a fundamental contradiction on the application of procedure. It would be, this is a hypothetical scenario if this is what happened, right? If the order that the judge signed was my order and not Morgan Heibner's order, which basically means throwing Morgan Heibner under the bus, because it would be admitting that the orders that she's submitting are bogus, right? But I mean, it would be like recognizing that fact, but the judge recognizing that fact and not signing that order and signing mine, when I'm not a trained lawyer, right? I mean, it would be throwing Morgan Heibner under the bus. So that's one implication. The other one is that it would be a fundamental contradiction in the application of the court's own procedural rules. Why? Because on the hearing of September 8th, when I was trying to enter into evidence and into the record, the Exhibit B, which was the transcript of my former partner, admitting to me in a recorded conversation that if we had reached an agreement in mediation, she would have dropped the request for a psychiatric evaluation, right? Which is basically admitting to bad faith litigation and using the psychiatric evaluation as a mean of coercion. When I was trying to admit that into evidence, the court did not let me because I did not know how to lay predicate, because I'm not a lawyer. I didn't know the magic words. You have to say a set of magic words. If you don't say those words, the magic tree doesn't grow. Right? There's a Charles book. I don't know if in English you have it, but it's a kid that he says magic words, and when he says those magic words, there's a magic tree that grows and goes, to the sky, to the clouds, and he can, climb into the tree. But so in these legal theaters, if you don't know the magic words, the magic tree doesn't grow, right? So on September 8th, I did not know the magic words on how to lay predicate to get this into evidence, and the judge did not let me get it into, the court would not consider the evidence because I did not know how to lay predicate. But now, if this is what happened, if he signed my orders on October 10th, I didn't even present the orders to the court. I didn't, because he didn't let me talk, right? So how can he apply the procedure so fundamentally differently that now he signed an order that I didn't even present? I mean, I submitted it in writing, but I submitted in writing at least 10 motions, and they haven't ruled in any of them. But then they picked this one document from that set of maybe 15 filings, and he signs that as an order. It's a clear bias. It's a clear. So when it's a piece of evidence that would benefit my case, if I don't know the procedure and I don't execute it precisely to the letter, then the document is not considered by the court. But if it's something that helps mitigate the legal risk of Morgan Heibner, even if I don't present it, it not only gets considered, it gets signed by the court. Right? I mean, if this is not, I mean, I don't know if this is what happened, right? But if this is what happened, the pipeline says this is, the smoking gun, right? That this is evidence that this core is a weapon. It's not, and this is the pipeline talking, right? Not Rinaldo. The pipeline thinks it could be argued that this is a smoking gun, that this court is used as a weapon, not as a court, right? And as a weapon that can defend itself using the same weapon, right? So it's mind blowing, right? If that's what happened. Of course, at this point, being 6:45 a.m., I do not know, right? I have to wait until the clerk sends me the written orders, the signed order, or this notice that was miscategorized as an order, right? So there was something. Sorry, I didn't take notes of the debug output. There was something else that I saw that I thought, wow, this is good. Let me see if I can recall. I can't recall. I can't recall. But there was something else. It wasn't as good as this, flagging, but it was good. Oh, yeah, I remember. So it co-clustered, right? This observation of the on equal application of its own procedural rules to something that happened. I mean, this is kind of a second order, right? But it's another piece of the argument, right? If the system was going to draft this argument, it would put this in. On September 8th, right after the court denied or told me, or that I could not get this into evidence because I did not know how to lay predicate, in my notes, it seems like, and we have to check the audio from the court, right? Eventually, they will have to give me the audio. But the judge said that because when I'm in that situation, right, that I'm trying to get this critical piece of evidence into the record, and the judge tells me, you have to lay predicate, and I realize, I don't know how to lay predicate, and I said, Judge, respectfully, could you give me a hint on how to lay predicate? And the judge said, no, I can't give you legal advice. I respectfully, said, okay, thank you, and sat down and shut up, right? And then minutes later, after this, Morgan Heibner, who is a licensed attorney, who has been licensed since 2013, she has her witness, the petitioner, on the stand, giving testimony, and she's trying to get admitted some of the things that they printed from my website to call me crazy. And she did not lay predicate either. And the judge stopped her and told her, counsel, you have to lay predicate. Remember the 4 steps. And then he recited the 4 steps to Morgan Heibner from the bench. So he gave her instructions on how to lay predicate, the very same thing that he denied a pro se litigant minutes before assistance with, because it wouldn't be legal advice. Really. It would be assistance on procedures of the court to a pro se litigant that does not have an attorney, right? So the legal vaccine would inject this inconsistency as a further proof of the procedural inconsistencies of this court. If this was the argument to be made, if this is what happened, if they signed my orders without me even formally presenting them to the court on October 10th. Of course, if this is what happened, it means that they saw the outcome of the October 10 hearing so catastrophic in terms of what got into the record. Because remember, when I said a couple of things already about that, right? Like the things that I got into the record. And what happened, right? The judge not ruling on the objection and all that. Maybe they saw this so catastrophic that they calculated that the less damaging step would be to sign my order, right? Oh, I remember what it was. The other thing that the pipeline flagged. In my orders, in my version of the orders, there was a clause or one of the temporary orders that got in there because I got contaminated by the fraudulent draft of Morgan Heibner. So what happened was Morgan Heibner put in her fraudulent orders that I had to surrender the passport of the child to her. Imagine that, right? And the judge never said the word passport or anything related to passport on September 11 when he rendered the verbal orders. The word passport is never mentioned. And he never said anything about the passport. Yet Morgan Heibner consistently put this clause in her 3 fraudulent drafts that she circulated. So for some reason, it is important to Morgan Heibner that she gets the passport. I don't know what she wants to do with the passport of my son. I don't understand that, right? I don't know what's the reasoning for her to want the passport of my son. But she wants it, right? And she put that in the orders, that the judge never said anything about the passport. Now, I got contaminated because I saw it so consistently that when I transcribed, when I from my notes, I created my proposed order to the judge. That order, I put it in there. But it wasn't really in what the judge ordered. That was never ordered verbally. And I put it because I got contaminated by the fraudulent draft of Morgan Heibner. But what the pipeline flags is that this is a tremendous contradiction because these orders are supposed to be temporary for 60 days. But surrendering the passport to Morgan Heibner is a one-time act that lasts forever. So that makes that the orders are not temporary, right? The fact, if the judge signs that order and the court orders me to give the passport to Morgan Heibner, those orders are not temporary because I have no guarantee that Morgan Heibner will give me the passport back in 60 days, right? She has now possession of the passport. So that makes it so that the orders in reality are not temporary orders. And that is a tremendous problem for this court. So I don't know. It feels like a major, you know. So at this point, I'm going to wait to see what are the orders, because I don't know, right? It could be one of three things. It could also be that they signed Morgan Heitner's order and the clerk made a mistake, and instead of putting 36 pages, put 3 pages in the metadata of the document, right? I don't know if they would have the power to make that change, right? I mean, the clerk. But that's also a possibility, right? There was a move to mislead me while I'm waiting. So I'm thinking that my orders got signed, right? But it wasn't my orders, it's Morgan Heitner's orders. It could be as well, right? So I have to wait and see what, you know, what in reality, what are the orders, right? So that's one of the things, right? Of the hypothesis or inferences that the pipeline, the legal vaccine pipeline specifically, is anticipated, right? And of course, I already have documents drafts for all of these options, right? Because I use the pipeline and draft the 3 documents. Whatever happens, I already have it ready to file, right? Okay, so the other thing, and then there's 2 other observations, right? And they have to do with filial relationships, okay? And they're kind of the same type. If I was to categorize them, you know, by the output, they came from 2 different pipelines. One came from the legal pipeline, and the other one from the anti-manipulation pipeline, the one that I described yesterday. And so these are 2 separate pipelines, but the 2 pipelines produce these 2 separate inferences that are filial in nature. I'm saying this because statistically, it's very unlikely that the 2 inferences are correct, right? Because it would be the probability of one being correct multiplied by the probability of the other being correct. So the combined probability is smaller, right? So I know that it's likely that one of the 2 things is wrong. But, you know, because it's 2 different observations, it's possible, it's more likely that one of the 2 is right than if I only had one observation that is filial, right? So that's why I'm going to say the 2 of them. I don't know if one of the 2 is correct or which one would be. But I know that it's very unlikely that the 2 are correct. That I know from being a statistician, right? That's because that's what I am in reality. That's my profession. So, I mean, I'm a software engineer, but my work experience through all these years in data science is basically applied statistics, okay? So there's 2 filial hypotheses, right? Things that could be. One is the pipeline flagged a last name match between the Chief Justice at the First Appellate Court and William Kyle Adams. So Justice Adams is the Chief Justice, and William Kyle Adams is the owner or the director or principal, I don't know what's his official title, of the Adams law firm where Morgan Heitner works. So the 2 of them are called Adams, okay? And William Kyle Adams is the son of another individual named Adams, who is the founder of that law firm, right? So William Kyle Adams, so basically Morgan Heitner's boss, and his father, both of them have the last name Adams, and both of them are lawyers, father and son, okay? What the pipeline flags is that Justice Adams bears the same last name, right? It's just an observation. It doesn't mean that they're family, but they could be related, right? Now, if they're related, in that event, right? This is a hypothesis, and it's not even a hypothesis. It's an observation that could be, you know, the question could be asked, right? But I don't have access to see if they're related, right? They have no way to see that. But if they were, it would be a conflict of interest, right? Because then the First Appellate Court would be ruling on something where the Adams law firm had their hands in from the beginning, right? So they will have to recuse themselves, right, before making that opinion and denying the petition for writ of mandamus, right? So I mean that would be an interesting development, right? If that was the case, I don't know if it's the case. And I have statistics about, I have statistics about names in the legal circles in Texas, right? How many lawyers are Adams, and I also have statistics on things like, it is more likely that if the father is a lawyer, one of the sons will be a lawyer, right? Like this is also a statistically significant observation. So I mean, there's things that hint that it could be possible. When I'm saying that, what I mean is more likely than random, right? The probability of this being the case is higher than a random event. So I don't know. I'm just going to put it out there, right? That there's a name coincidence between the Chief Justice on the first court and the Adams law firm, right? William Carl Adams, his father, both are named Adams, and the firm is named Adams. And the pipeline flagged these or co-clustered these with a conversation in which my former partner told me that Morgan Heidner told her that she could not represent her on the appellate court because she did not know about this topic, right? This is one of the things that, when I say, if you look at the boxes, this checks all the boxes, right? This would explain why Morgan Heidner could not represent my former partner, because then her name and the name of the Adams law firm would appear in the counsel box of the petitioner, right? Right now, she gets the emails, but it's only her name, Morgan Heidner, and her email. It doesn't say, she's not listed as the counsel, right? Because my former partner had to retain another counsel. So this would explain why, right? Because the more logical step is that Morgan Heidner represented her on this because she already has all the context about the case, right? She could more easily, she doesn't have to get up to speed. She already knows everything that there's to know about the case. So it would be more logical for Morgan Heidner to represent her. I thought at the time, well, she's just running away from the problem, right? She's trying to get more sophisticated lawyers in to help her, right? But on the other side, Morgan Heidner is on the record saying that she charges $450 an hour, and she's one of the most experienced lawyers in Katy. She basically said, I mean, didn't say with those words, but what she said implied that she is on the top tier of pricing of lawyers in the area. Right? That's what she implied and she said this to the court on the record. So somebody that thinks about themselves so highly seems contradictory to me that are going to, in particular in a case that touches their own interests, right? Because she is getting legal exposure, obviously. Now she's on the federal lawsuit as main defendant. So she obviously has to feel the heat and the exposure, right? So how she's going to delegate that to another person, unless it's somebody that she knows is more capable than her. But because of the way she speaks about her qualifications in the court, I think that she's one of those people that think very highly of themselves, right? And she would think that nobody would do it better than her. Nobody could cover her better than her, right? Herself. So that's kind of a contradiction to me. Why she said to the petitioner that she couldn't represent her. I thought it was a way to bring bigger guns. But with this flagging of the pipeline, I can see how that would have been needed, right? To avoid a situation in which the justice that is going to, deny whatever I petition has the same last name as the firm of the counsel defending the real party in interest, and indirectly the respondent in that action, which is the judge, right? So, but if this turns out to be the case, it would be interesting because it means premeditation. Morgan Heidner got herself out because she knew of the filial relationship, and she was preventing this to come up, right? Instead of bringing it up, which is the thing that she's obligated professionally to do, right? If you know there's a conflict of interest, you have to say it. You can't hide it. She hid it, right? If this is what happened, right? I'm talking hypothetically if this turns out to be the case. Again, I don't have the tools, and it's not my job to see if it's the case, right? I'm just saying an observation that the pipeline software system issued, okay? And if Morgan Heibner takes an issue with that flagging, please sue the pipeline. Now, that's the second thing. The third thing is also filial, but this comes from the anti-manipulation pipeline. And as I said before, I know that it's unlikely. It's very unlikely that the two things are right. It's unlikely. So I know one of the two must be wrong. It's very likely to be wrong. But I'm going to say it anyway because I don't know which one of the two is. It could be the one that is correct. So the anti-manipulation pipeline flagged a series of conversations that have happened recently between my former partner and me in the black Tesla, always in the black Tesla. And these conversations, the sequence is something like she remembering, or remember is not the word, she nodding, she making a comment that reminds me that she and her sister were the only two female children, that their parents had. I don't know if that makes sense in English, but I'm going to give you an example of what the conversation looks like. So she would say things like, and there's like 4 occurrences of this in the last 2 weeks. It's like, for example, one example is, yeah, I don't know how I would be if I had a girl instead of a boy, if Marcelo was a girl, because I'm so used to boys, to raising boys, that I don't know what it would look like. Which is ironic because when I was growing up, it was only my sister and me, and we were 2 female children only. So she inserted that statement there, that she and her sister were the only 2 female children. And this type of conversation, different wording, different contexts, in different situations, but the consistent thing is that she mentions that she and her sister were the only 2 children, female children. In Spanish, she uses, niñas, which is like girls. And she uses that word consistently, to say that there were only 2 children and that they were both female. So the anti-manipulation pipeline flags that this phrasing is something that is coming up recently in the last 2 weeks, and it hasn't come up in the last 6 months. Because I know that there are only, that's what they told me, that there are only 2 female children, Jenny Espina and her. But now in the last 2 weeks, this topic keeps coming up and up and up. So, and this, I don't know, so I have to think, what is the need to remind me that there are 2 female children? So it occurred to me that maybe she has a brother, that I don't know of, that they never introduced me to. And of course, this is, I don't have a way to prove it, But let me show you. This is just a hypothesis. I don't know if this would be the case, But it's something that could be, Let me open a new window here. Sorry. Yeah, sorry. I should have done this before, but. Yeah, so there is this guy, that at this point, I think his name is Daniel Molero, And my sister confirmed this by looking at the photo. And my sister went to school, or the same school in similar years, maybe not the same class, but very close by, And my sister confirmed that this is Daniel Molero. And remember, as I have noted before, every time I mention Daniel Molero, she starts crying uncontrollably and becomes a little bit violent, even, She starts telling me things and insulting me. And so I thought at some point that maybe when I, before before I ran the pipeline with the photos of the Christmas of 2009, right? But before that, at some point, I thought, because she was crying so uncontrollably when I mentioned this person, that I thought, well, maybe this is the real ex-husband, right? But with this flagging of the pipeline that she's bringing up constantly that there are only 2 girls in her family. And I look at this photo, I have to be honest, the features of this man do seem very similar to hers. I mean, the color of the skin, the shape of the lips, the color of the hair. If my former partner was a woman, she probably would look something like this, right? Or she would have similar features, right? So it's possible, right? I guess the theory, the hypothesis, really, it's just a hypothesis. I don't know, and it is not my job to prove this, right? But it could be that this is the brother or somebody related to her. And also, the pipeline co-clustered this with the transcript of a demo I gave months ago, in which I described the following situation. I'm going to recount it here. The situation is that in one Christmas, when Harold Martinez was visiting here, supposedly Katie, right? I don't think he was visiting. He probably lives here, or in Florida, right? But he was here, and it was Christmas, and my former partner and him, and I think even the baby, Marcelo wasn't a tiny baby. They all were using matching pajamas. Right? They bought these Christmas pajamas, and they were all wearing these matching pajamas, which seemed weird to me. Like, grown-up people, I don't know. Maybe it's a thing, I don't know. But in my family, I never saw that, and it caught my eye. Now, on a separate story, years ago, Patricia Rojas, who was the wife of Francisco Castillo, she showed me a Christmas photo of her with the Moleros, and there was a big group of people, and they were all wearing matching pajamas, right? Patricia Rojas and all the Moleros on a Christmas, I think around 2020. So the matching pajamas again, right? So my former partner wears matching pajamas with Harold Martinez, and Patricia Rojas wears matching pajamas with the Moleros, right? Could be a family thing, I don't know. And the pipeline, the anti-manipulation pipeline, also flagged a series of conversations recently in which my former partner has repeatedly asked me to bring her a box that cannot be found anywhere, but she insists is in that house, that contains the Christmas pajamas, right? So the Christmas pajamas are important to her because she wants those pajamas and she can't find them anywhere. But again, the matching pajamas, right? So it could be a family custom. I don't know. It could be a family, a tradition, right? In this Molero family. So I don't know. It could be something, right? But I don't have a way to prove it, or I don't think it's my job to prove that, right? But if that's the case, even if they destroyed all the documents, I think authorities can use the ultimate filial document, right? DNA. You take a sample from one, you take a sample from the other, and you see they're related, right? It's silly, really. But I'm mentioning this because I know that, I've seen through all the things that I've seen through the years that obscuring the filial relationships is important for the operations, right? And obscuring the real names, right? Doing things like misspellings or using the middle name instead of the first name, or using first names that could be last names. Like, for example, Tyler, right? Like, you know how she's Morgan Tyler, right? So that middle name could be misread as a last name. So, that is a thing that I see all the time. Middle names or first names that could be last names in American society that are common last names, but they're used really as, this is just a way to create confusion in the records, right? So people don't know which one is the last name and the first name. So those are the 3 things that got flagged. Okay, so I'm gonna end this session here, and thank you so much for your time, and I'll see you on the next one. Bye bye.